Could a sitting United States president legally cancel or delay the midterm elections? This is a constitutional question, not speculation, and it has never happened in U.S. history. It probes the very structure of American democracy. Thankfully, it remains theoretical, not practiced. No president has ever attempted such an action. To find a clear answer, we turn away from opinion and speculation and toward the nation's foundational legal texts. The answer lies in the U.S. Constitution, federal laws enacted by Congress, and the rule of law principles guiding the nation for over 2 centuries. It is a constitutional question with a clear answer. It is not about whether crises make elections difficult. Through wars, depressions, and pandemics, elections have proceeded. The United States Constitution is the supreme law of the land, and it provides the primary answer. It is clear about who regulates federal elections. Article 1, Section 4, Clause 1, often called the Elections Clause, states the times, places, manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. But the Congress may at any time by law make or alter such regulations. This language is unambiguous. States set the rules first, but Congress has the final authority. The president is not mentioned. This power is deliberately separated from the executive. Letting a chief executive time elections for his checker creates an irreconcilable conflict of interest. It would open the door to tyranny, even rule without a functioning Congress. House members are chosen every second year and serve 2-year terms. Senators serve 6-year terms. Terms end automatically on January 3rd after the election. If an election were canceled, all 435 House terms would expire. 1/3 of the Senate would expire. The legislature would be crippled, an immediate constitutional crisis. A president cannot extend terms by decree. The Constitution is the starting point. Election timing power resides with Congress, not the president. No mechanism, no loophole, no emergency provision grants such authority. Any attempt to alter the schedule would defy Article 1's text and intent. The Constitution's silence on presidential power here is telling. The executive has no such authority to begin with. Following constitutional authority, Congress enacted laws regulating election timing. These statutes leave no room for executive discretion. An 1872 law, now in Title II, set a uniform congressional election day. Representatives are elected on the Tuesday next after the first Monday in November, every even-numbered year. Similar law applies to Senate elections. This is a binding statutory date, not a guideline. To cancel or delay, a president would have to suspend or repeal federal law, a power he does not have. Only Congress can make or unmake laws. A president can sign or veto, not nullify a duly enacted statute. An executive order contradicting statute would violate separation of powers. Courts would almost certainly find it illegal and void. States administer elections. They would proceed under their laws. They print ballots, set up polling places, and count votes, decentralized by design. The limits of executive and emergency powers. Some argue emergency powers could justify a delay. Statutes like the National Emergencies Act grant specific tools to protect national security, manage disasters, and respond to public health crises. These powers are delegated and limited. No law grants power to move or cancel federal elections. Courts have policed crisis powers before. In 1952, Youngstown versus Sawyer rejected presidential seizure of steel mills. Jackson. Power is at its lowest when contrary to Congress's will. Canceling a Congress-scheduled election fits that category. No inherent emergency authority suspends the Constitution. The Constitution rejects an all-powerful executive. There is no escape hatch to suspend the elections that secure representation. Legal and political responses. If a president ordered midterms canceled or delayed, the response would be immediate, widespread, and multifaceted. First, the legal system. Civil rights groups, state attorneys general, and Congress itself would sue for immediate injunctions. Cases would be fast-tracked on overwhelming constitutional and statutory grounds. Federal courts would likely block the order, and the Supreme Court would likely concur. States would move forward under their mandates. Ballots printed and polls prepared, elections could still occur in many locales, creating legal and political turbulence. Political consequences in Washington would be severe. Congress would erupt in opposition. Members of both parties would see it as an assault on the legislature and the Constitution. The House would likely initiate impeachment quickly. The charge: violating the presidential oath to preserve, protect, and defend the Constitution. Opposition could unify across party lines. Public reaction would be profound, with mass peaceful protests. Financial markets would face extreme uncertainty. Markets rely on predictable rule of law. Military leaders swear an oath to the Constitution, not a person. They would confront what they recognize as an illegal order. Combined legal, political, and social pressures would mount. The decentralized American system is resilient, even amid conflict and litigation. Elections in times of crisis. The United States has an unbroken history of holding scheduled federal elections, even in severe crises. That precedent is a potent check. In 1864, with the nation at war with itself, President Lincoln faced re-election. Calls urged delay. Lincoln refused. The election proceeded. 1918 midterms held on schedule during WWI and amid the deadly influenza pandemic. 1942 midterms and 1944 presidential election were held. In 2020, states adapted, expanding absentee voting and safeguarding polling places. The election proceeded on time. This long history forms a powerful norm. Suspending elections would defy law, tradition, and democratic continuity. Elections continued through the Civil War, World Wars, pandemics, and depressions. Canceling midterms would be a first in American history. It would break from constitutional governance and separation of powers. The system's guardrails exist to prevent it. It would threaten peaceful transfers of power and legitimacy. Predictable elections are the backbone of trust. Citizens rely on regular, lawful intervals to choose representatives. The framers, wary of concentrated power, built checks and balances to protect elections from executive overreach. Article 1 grants Congress, not the President, the authority here. There is no constitutional or statutory mechanism for a president to cancel midterms. Any attempt would be extra-constitutional and illegal. In summary, can a U.S. president cancel or delay midterms? The answer is a clear and unequivocal no. This is based on law, not opinion. The Constitution grants Congress the timing authority, not the president. Congress set a uniform election day by law. A president cannot unilaterally change or ignore that law. Emergency powers cannot suspend elections. Courts would block such an order. States would proceed under their mandates. Congress would likely initiate impeachment. Checks and balances, federalism, and the rule of law prevent power concentration. U.S. democracy relies on regular, automatic elections, and the law ensures they continue.